that this panel will be the longest, but I'm going to make it as short as possible, sweet and short. And I've been told, oh, of course, we've got a very good, sweet topic. So I think it should go off very, very quickly. And I've been bribed already by other co-panelists to make sure that this panel goes off as quickly as possible. So on that note, I don't think any of them actually require any introduction. All of us are very well aware of who all they are. And so without wasting too much time, let's start with Mr. Nayar and ask his 2 bits on how he sees mediation in the IBC.
Before I come on the topic, just a comment. I think when you start talking about panels being very sweet and finishing, I think the moral of the story is we should be a little careful of scheduling panels on Sunday, because we have at least 6-8 speakers in the speakers lounge rooting for us to finish very quickly. Because I think they've all sacrificed their afternoon siestas. So about mediation, just a little bit of background for a minute or two before I get on to that. I am a great admirer of this legislation, which is very new and which I think has achieved a lot in the short period that it's been around. There has been a lot of resolution, and the problem is, just with any new process, you also have a very high percentage, I don't want to go into numbers, but you also have a very high percentage of genuine corporate debtors who are losing control of their companies and their assets, and that's where debt restructuring and mediation comes in. I think if we push this formally, we will be able to be in a position where we'll be able to separate the genuine companies, the genuine corporate debtors who are pushed in towards insolvency and towards losing control of their companies and assets for various factors and reasons which may not actually entirely be in their control. I think a case in point is we are all still recovering from the 2 major lockdowns and a pandemic. And I think there were hundreds and thousands of companies who saw some very tough times because of those factors. And for such genuine companies, if there can be mediation, if they can get one more shot at trying to revive their companies and to keep control of their assets, I think it would be a very positive development. I can say from personal experience, without taking names of the case of those particular cases, that we are at a point where councils are starting to suggest mediation. In fact, I recently saw a case of a lawyer, and apparently it was a family-owned company of the lawyer, where there was an NCLT order of admission, and in the 3 days gap that the appeal was drafted and listed before the NCLAT, they had approached the financial creditor and sorted out the whole issue. So mediation is huge scope. We just need to somehow formally incorporate it so that debt restructuring proposals and conversations between various stakeholders can take place and reach a better result.
That's actually a great thought. 3 days and everything gets sorted. No, I don't think mediation as such would arrive in such a quick time. Shweta, what is your take on this?
So my take is a little more pragmatic, and I totally agree with what Mr. Nayar has mentioned. It is, mediation is here to stay.
Right.
Mediation is ingrained in our system as a ethos. I think if you think about the older systems for resolution of disputes also, I think mediation was the one process which was adopted. Now, over a period of time when you have started talking about ease of doing business, I think the first step of ease of doing business was to include insolvency in the process as a law. The second is now to make it a little more seamless as a process, because insolvency otherwise, from the time it started in 2016-17 and from then to now, the kind of timeline that we have started breaching is of, it is making a considerable impact in terms of the stressed assets and the value that it is getting lost. So when we are able to introduce mediation as a process, I think there would be some expeditious resolution of certain issues, which are the reasons why it is getting delayed in the first place. So I think for that one purpose, it is very important to have mediation as a process included in the system. The second is the success of it that has been seen globally If you look at it, I was in Japan last week and I actually heard a lot of discussions from the Japanese lawyers also about the success of mediation in insolvency.
Right.
So which means, and again, Japan also has very similar, ethics and ethos like us. They also are very pro conciliation and mediation, and they are not into, too much of disputes. So they said that we have adopted resolution of disputes through mediation very successfully, and it is working very successfully in the insolvency space as well. Similarly, for US, I think if you look at their group insolvency, which is also getting resolved through mediation, so that is a success in point. There are Dutch judgments also. If you see, the insolvency process, has been expedited by way of mediation. So I think mediation has played a very integral role in terms of resolving the disputes and reducing the timeline that are required in various other jurisdictions. And I see that that can be replicated in India as well. And I'll just take 1 minute to give an illustration of it in one of the matters that I was handling. Now this is a matter before NCLT where the dispute is about 3 crore 54 lakh.
Yeah.
Out of that dispute, the other side says, no, 3 crore is something that I'm admitting to, but this 54 lakh is disputed, and because of which I'm not making the payment. Now imagine if you are ready to pay 3 crores, then ultimately the court also said the same thing. You pay 3 crores and for 54 lakhs you can go ahead with the resolution of dispute. But then the fact of the matter is, if we had possibility of doing a mediation, we could have probably resolved some of those issues, and we would have spent less time before NCLT. And there are multiple such examples that
No,
I can
agree.
throw upon you on
I
this
totally
aspect.
agree, and thank you so much for giving a world view of how it is working. Pooja, what's your take on this?
No, I completely echo what Mr. Nayar said and what Shweta said. I'll just give maybe a couple of points from my perspective. I think the first thing is that mediation is eventually a means of resolving a dispute. So any area in insolvency law where there is a possibility of a dispute, mediation can be adopted. According to me, we need to have, if we are going to be introducing a mediation mechanism in insolvency, I believe that at least to start with, we need to make it voluntary and not make it mandatory, because it's very important to also make sure that mediation is not being misused by the parties to actually prolong, let's say admission process, or even prolong the disputes. So I think that is very critical, and I think the other very critical thing about mediation, which will actually determine its success in insolvency, is the quality of mediators. Especially in insolvency field, I think it's extremely critical to have people who understand business and who understand how to resolve these type of disputes. And I'll give an example. And this is especially relevant where a creditor and a debtor are negotiating a repayment plan.
Correct.
It's especially critical in pre-insolvency cases where insolvency is imminent and a genuine debtor, what Mr. Nayar just mentioned, that we need to give chance to a genuine debtor, right? I think mediation can really be a bridge that will help in bringing back that trust between the debtor and creditors if debtors are encouraged to actually start mediation at an early stage before it's too late and before the company actually goes into insolvency, to avoid insolvency, to have a mediation process where there is a mediation between the debtor and various creditors to see how best the debt can be restructured. To give an example, there are a lot of jurisdictions, and I was attending one of the World Bank's module on mediation and insolvency, and one of the examples that one of the delegates gave of a case in Italy where businessmen, for instance, are mediators and were helping debtors and creditors resolve the disputes. And they had business acumen, and they were really helping out debtor in actually figuring out how to cut costs, how to bring operational efficiency, giving their suggestions. So quality of mediators is absolutely critical, I think, to make it a success.
That I think is actually one of the most relevant things that you've pointed out. Kunal, what's your take on this?
So my take on mediation in insolvency, I totally agree with my learned senior colleagues here. I think we need to break down as to what kind of mediation we are looking at in insolvency. One is pre-insolvency completely, in the sense that pre-application also.
Right.
To an extent, it is available in our Companies Act also, where you can kind of restructure it with your creditors and get into some kind of restructuring, go to court, get an approval of that court. It's It's a process which was available in the old Companies Act. Second is, once the application is made, at that stage, can the mediation be incorporated in the insolvency code? Third is, obviously, if the application is admitted, at that stage, once the CIR process starts, whether mediation can happen at that stage or not. The other point we must keep in mind is that it is an action in rem.
That's right.
It is not an action in personam. It's not that Pooja and I are fighting with each other and there will be Mr. Nayar who will say that, listen, you two please stop fighting. It is that the entire panel is fighting and entire panel has to be taken into consideration.
Absolutely.
So we have to take all those aspects into consideration. And I think it is that reason why in 2016, when the code was enacted by the parliament, that mediation was never thought out. Mediation in insolvency proceedings, I think, is a complicated process. As we see it in the United States of America, it started in '86 as against mediation otherwise, which had started in America in, I think, 50s, late 50s or something.
So? Yeah.
But in insolvency, it started in '86. The first case I think they did was the Greyhound case.
Oh, yeah.
Yes, where they actually decided all these issues step by step.
Yeah.
Claims which could be settled, the claims which could not be settled, the claims which were really complicated. So they divided this and achieved some amount of mediation in this entire insolvency realm. So I think it is time for us to get mediation into insolvency with a proper procedure in place, which the authorities are studying now.
Right.
And surely I'm quite optimistic that it will resolve a lot of issues which are pending in courts right now.
On that optimistic note, what do you have to say, Mehak? Because I know Nakul has a very negative thing to say, and I'm really hoping for him.
Mediators are like marriage counselors for businesses, except you're not arguing about who left the dirty dishes in the sink, but who's going to keep the sink.
Yeah.
So yeah, anyway, on a serious note, I think this is the stark reality that it's a zero-sum game. The winner takes all. And so it's very important to transform this adversarial landscape into a collaborative one. And, just to put out some stats out there so that we understand really what we're talking about. As per the NCLT data itself, only 12% of the cases are getting resolved, 88% are pending. And it's taking an average of 4.5 years to resolve the cases. So mediation is the need of the hour. It's a necessity.
I am so keen on hearing your observation because...
No, so having heard everyone, I think so my point of view is a little different.
Yeah.
And I would first want to give the reasoning for why I think otherwise. Insolvency is not a mode of dispute resolution. Insolvency is not based on there being a dispute. Mediation by itself is a form of alternative dispute resolution. It's a form of ADR. So when there is no dispute, what are we going to resolve through mediation? We first need to understand this. Secondly, if we see, if an operational creditor files for insolvency, if the corporate debtor is able to show that there is a dispute, the insolvency fails. So you would have had mediation to solve a dispute, but if a party shows the dispute itself, the insolvency fails.
That's correct.
So the parties will be relegated to the normal Commercial Courts Act or any other arbitration act, and there you can explore mediation. When we come to financial creditors, which is the second mode by which insolvency can be initiated, in that, ideally, there are only three prerequisites that the tribunal needs to see. And none of those prerequisites actually circle around a dispute.
Right.
And insolvency ideally arises when a party is not able to stand on its obligation of making a payment. There is no dispute here that needs resolution. When there is no dispute here that needs resolution, there is no need to have a mechanism to resolve the dispute. And ideally, the Act gives a 14-day time period to the tribunal to either admit or not reject a petition. We all know that's not happening in the 14-day period.
That's correct,
If a
yes.
party actually wants resolution, then they will have enough opportunity within those initial 14 days to say 3 months time period to resolve a dispute. But by introducing a specific mechanism to send the dispute for mediation, it will not only just prolong, but will give the corporate debtor a lot of reasons to delay it further. We also need to understand that the Commercial Courts Act came before the IBC.
That's right, 2000.
There was a specific provision in the Commercial Courts Act for pre-dispute mediation. There is no specific provision like that in the IBC. The legislative intent thus shows that at that point also it was not contemplated because insolvency procedure is absolutely different and operates on a very different sphere than a dispute resolution mechanism. So that, I mean, my thought is based on
I
that.
understand Nakul and I are actually against each other in a few matters, so I don't think we'll ever have mediation in those. But coming back to you, Mr. Nayar, the question that I have is that there is, globally we've seen that there is something called as debt restructuring agreement. Do you think India has that form, or do you think it's workable in India?
See, I think there are, first let me just straight away, before I come to this, let me just respond to what Nakul said. I quite agree with Nakul in the sense that unlike the Commercial Courts Act, you can't have a prerequisite of mediation like the conciliation that is there inbuilt in the Commercial Courts Act, because the potential for its misuse would be immense. I think a lot of time, we are in any case missing all the timelines that are given in the IBC in most of the cases, and that's clearly because of the rush of cases that are there, the sheer number of people who go to court in this country. So if we had a prerequisite of mediation, the potential for its misuse would be a lot, and I think parties would be constantly taking time about whether my notice was received, whether we had a conversation, whether this is adequate, good service or not. So we can't have a prerequisite. When I referred to mediation, what I meant was that in case of genuine issues, and I agree with Nakul, the intent is not to resolve a dispute, the intent is to resolve the corporate debtor. But what happens if, understanding the urgency, the promoters or the management of a corporate debtor understand that this is their last opportunity before they lose control of their assets, which have some potential to be monetized. And just to make my point, I'm going to give an example of a case where I was appearing, again, no names. I was appearing for one of the leading public sector banks, and the adjudicating authority rejected the petition for the grounds being that they were in a niche business, they had good machinery, they were doing some very sensitive contracts, so they should not be, CIRP should not be admitted. And the appellate tribunal, despite agreeing with us that there was perhaps an error in what the adjudicating authority had decided, and its reasoning said that, look, we are conscious of the nature of the business that this corporate debtor is in, so let's try and give them an opportunity. And what happened in that 6-month, 4 or 5 dates that we took, eventually they ended up paying. So that's what I mean when I talk about the potential of mediation. It has to, of course, that initiative perhaps has to come from the benches. The only thing is about corporate debt restructuring, that also envisages parties talking about changing the terms, renegotiating interest rates, renegotiating lump sum payments. So that can be connected to mediation. But of course, the note of caution is that this will have its own problems. For instance, mediation and arbitration and conciliation, one of the factors is that parties should have some sort of equality, negotiating equality, and that's why the Honorable Supreme Court struck down that clause of unilateral appointments. Here, what we are seeing already in pending cases is that somebody who's sitting on the cusp of a Section 7 petition being admitted, why will he agree to mediation even if the intent of the corporate debtor is true? So I think what we'll need to focus on is who initiates mediation, who are going to be the mediators, the quality of mediators. Pooja also mentioned, others also said, quality of mediators is very, very important. One or two cases where I'm appearing in, the bench has referred the matters, certain aspects of the dispute to retired members of the adjudicating authority. So that's perhaps one factor.
That's actually true. I mean, it is the intent of the corporate debtor whether or not they want it to be resolved. On that note, but Shweta, the thing is that, Kunal said that it is not in rem. It's going to be, it is in rem rather, it's not in personam. So now do you see that the mediation has to be done individually with each and every creditor, or do you think there can be some kind of a resolution which can be brought about, in terms of all the OCs together and in terms of all the FCs together? How do you foresee that?
It's actually going to be a very interesting scenario that we are actually envisaging just now. And before responding to that, I also would want to touch upon what Nakul has said, because we all have been propagating
Nakul's
mediation.
got a Pandora's box
so you
open
have
just
opened
now.
a Pandora's box, and which probably needs a response, and I'm sure each one of us would have a feeling towards it.
So nobody is giving closing remarks now. This is all that we get.
So if you look at the number of Section 12A petitions, that applications that are filed before the court, or even Section 30A1 of the CIRP regulation applications that are filed before the court, that in itself speaks volumes about the potential of mediation that exists in the insolvency process.
Yeah.
So it's not only about A versus B at all times, it is also about situations which can be resolved and for which we have to go up to the Supreme Court many a times to be able to get this order. So if we are able to resolve it through mediation, I think we will be able to reduce a lot of substantial time. So that was one bit that I wanted to add. Now coming to your question on how is it going to pan out, because it is otherwise, the insolvency proceedings are proceedings in rem, and if we have to resolve it through mediation, how does it pan out? And therefore probably why it has to be kept out of the Mediation Act. That is the first step that has to be done, is it has to be in the exclusion of the Mediation Act, because it cannot be a part of it. Second is, if it has to be mediated, I think there would be certain issues which can be resolved through mediation, and for which there could be, in REM kind of a proceeding, which could be initiated to resolve certain kinds of issues which are common to multiple parties.
Yes.
I think that would be the one way of, looking at a solution around it. And secondly, also, if we are able to arrive at, a common solution, probably a settlement agreement or
That's
a
right,
mediation,
yeah.
a settlement agreement kind of a MSA kind of a document which can be executed, and that can be separately enforced, and for the rest of the issues, any which way the CIRP process is going on. So I think we will have to bifurcate the issues into different parts and then look at mediation. It cannot be one size fits all.
That's right.
Definitely not in mediation.
That's
for
right.
sure.
Yeah. Pooja, your comment on Nakul's thoughts, one, and secondly, also on where do you foresee mediation to fit in as far as the CIRP process or the IBC process rather is concerned?
Sure. I mean, just on what Nakul is saying, and I'm completely on board that we should not allow it to be misused. And it needs to be voluntary according to me. So only if parties agree to mediate, that's when the mediation should actually be triggered. As far as proceedings in REM is concerned, of course, we all know insolvency is proceedings in REM, but within those proceedings, you will find specific areas of dispute, which do have a scope for mediation. And I'll give 3 examples of this. One is a case that my learned friend, Mr. Tandon, is fighting against our client, where there is a CIRP process going on. We are representing the RP. And there are disputes that have arisen between the corporate debtor and one of the critical operational creditors. I would personally like to think that that dispute can be mediated to keep the company as a going concern, and there could be some give and take within the process. So yes, there is scope in some areas which can be explored. Another example is inter-creditor disputes, for instance. There are a lot of, and it happens a lot even practically when you sit in the committee of creditors meetings and when you're negotiating a resolution plan. A lot of disputes happen inter-creditor, and these disputes are related to, well, my security is this much, why should I not get this amount from the plan, right? You will have cases where unsecured financial creditors will be saying that, even though I don't get anything under the waterfall, I should be getting some amount. You may have cases where there may be home buyers sitting in a COC, saying that this is what we want out of a
Which I
resolution
think
plan.
you argued last week before Justice Chandrachud.
Yeah. So there can be different scenarios here where inter-creditor there are disputes, and I can tell you practically how it works is there is a lot of give and take. I attended a COC meeting last week, again, no name spaces, where creditors inter se were trying to figure out that yes, if this is a resolution plan amount, how much do I give to each of the categories of creditors? There were discussions happening. Those are the kind of things where I think mediation has some scope, because sometimes these issues get prolonged. It could take a lot of time for inter-creditor issues to be resolved, and if you have a very seasoned mediator who can negotiate between various classes of creditors, types of creditors, it has some merit. And of course, these are proceedings in REM, but there is some merit in some areas to look at mediation as a solution. Another example I'll give is plan implementation. We have cases where after approval of a resolution plan, when plan is being implemented, disputes may arise between a successful resolution applicant and the committee of creditors. Payment timelines sometimes get triggered. COVID happened. People are not able to pay on time. They need a little bit more time to make the payment.
That's right.
Again, there is a scope for mediation in these
Correct,
cases.
yes.
Personal insolvency. I think there is a huge scope for mediation in personal insolvency matters.
Kunal, there you go. Of course, you can answer to Nakul. And also, my question to you is, how do you see IBC has been so far? And why do you think the mediation was never envisaged at the inception of the Act?
Okay, I think everybody has already answered the concern that Nakul raises. Nakul raises it in a negative sense. My panelists on the right side raise the same concerns in a positive sense. So that's the difference according to me.
I think I read something somewhere today where it said that, an optimist builds a plane and a pessimist builds the parachute. So I think
Yes.
Nakul is just building up the parachute.
So he's building the parachute for the plane.
That's correct, yeah.
So both the things are two sides of the same coin at the end of the day. The concerns are genuine. And that's why when I said that the way and the manner of mediation is still to be worked out. It can't be mediation that we've seen in our traditional sense.
Correct, yes.
Why it was not included in 2016 probably, according to me, is that IBC was a very new legislation at that time. Even the parliament thought that let's test it out first. Second, I think over a period of last 7-8 years that we've seen IBC, we've also seen innumerable amendments to IBC.
That's right.
So as we grow with IBC in various courts, the government have taken cognizance of that issues and they've ironed out those creases wherever it was needed. Mediation is here to stay. If we think that mediation won't come in insolvency, I think we'll be wrong. Mediation is going to come in insolvency. In what form it comes is yet to be seen. And I think I agree with both Nakul and Pooja that it can't be mandatory. It has to be voluntary. Because it has that thing of being misused. So we are yet to see how it is going to come in and how it's going to play out really.
Yeah.
So, yeah, that's
On that note, Mehak, I remember our conversation yesterday where you said that, how is it that it's going to fit into the timelines? What are your thoughts on that today?
So, I think it needs to be a facilitative tool to the existing timelines, to supplement the existing timelines and not replace the existing timelines.
Right.
So when I say that, what I mean is that during the CIRP process, you can concurrently hold mediation. So that way it doesn't impact the timelines. You stay within that. Another way to help not impact the timelines would be that you get trained full-time mediators. Right now, majority of them are part-time mediators. So if you want to make the process more expeditious, you need full-time mediators.
Or maybe the quality, like they said,
Yeah.
maybe a businessman or somebody
Yes.
who's invested in it that way.
Yes. And the last thing is, a lot of the times what I'm hearing here is that, at least from Nakul, what I heard was that it will prolong the process, right? I think it's a misnomer that it's going to prolong the process. Just to give you an example, George Lim, the chairman of SIMC, he concluded a $1 billion mediation in 1 day.
1 day.
I myself have co-mediated a matter which was in the NCLT for 3 years when we wrapped it up in 2.5 months.
Oh.
So in fact, even Sanjukta was speaking yesterday, right? She said that the international standards are, you know, they lock themselves in a room for 2-3 days and they're done.
Correct.
So I think it's the intention that matters.
That's true.
Yeah.
Yeah. So Nakul, have my panelists been able to maybe change your thoughts? Or,
No, I mean, see.
are we all litigation oriented?
No,
only
like
now?
like Kunal said, like you also said, both of them are sides of the different sides of the same coin. It's just how you look at it. One of the thoughts that came across was that, you know, when you have a company which is doing well and is otherwise not in any amount of stress, but you still take the company to insolvency because the corporate debtor does not go by one of its obligation of making a certain payment to a certain somebody, that's not correct. So that can be avoided. You know, when a company goes into insolvency, a corporate debtor who's not otherwise barred under 29A can actually buy back the company. I mean, can file the resolution plan, take back the company.
Correct.
If you believe in your own company to that extent and you're not barred under 29A, no one holds you back from taking your own company back. 1. 2, let us see what are the type of bars that you have under 29A. The bars are if you're a habitual offender, you are declared NPA, you are in the defaulters list. These are the primary bars.
That's right.
Now, would you want to give members of a company who come under these bars a second opportunity via a mediation route? Let us see also who we are trying to help.
Right.
Because if these people don't fall within these criteria, they can help themselves by filing a resolution plan, giving the best value and taking their company back. And lastly, during that period of CIRP, the RP performs a very essential function, which is to do the preferential undervalued transactional audit. So a lot of times, if there is something actually rotten in a company, it comes out in that audit, which otherwise it never would. So, I mean, a corporate debtor is never barred from taking back his own company in case he doesn't fall within the parameters of a 29A. So that works well overall. I mean, that is something that we can all think about. That would be my parting remark.
So I think that all of our fees is at least secured till such time that this is not getting sorted. But yeah, absolutely. Why not? Maybe that. So on that note, in case there are any questions, we are open for that. Otherwise, I'm sure the buzzer is still not on. So there. Oh, the buzzer is there. We've done it within time, just about a minute over. Yeah?